Hello friends, in the series on the income tax cases, today we will discuss a very important case on the service of notice. The name of the case is 4-Star GRANITE Private Limited versus Deputy Commissioner of Income Tax, and this case has been reported in 444 ITR at page number 161. The case has been decided by Kerala High Court and the date of the judgment is 29th March 2022. There is a section in Income Tax Act, section 282, which says about the issue of notice generally, and there is one rule 127 which give the detail of how the notice to the assessee should be served, whether it is a notice, whether it is a summons or whether it is a order. Nowadays a lot of dispute is coming that the assessee is not able to receive the notices, due to which some very big assessments are being made, due to which the assessee has to face the litigation. In this case, notice under section 148 was issued to the assessee, and according to the assessee, this notice was issued to the email ID of the professional who was the previous auditor of the assessee. But the department was saying that this notice has been issued to the assessee on the email address which was there in the income tax return for the assessment year 16-17, while this matter was related to the assessment year 17-18. It was the contention of the assessee that the assessee has not got the notice because it was served to the, or it was issued to the email address of the erstwhile auditor. So assessee was not aware about the notice. It was also the contention of the assessee that the assessee has updated the primary email ID and the secondary email ID on the income tax portal. When all this matter came to the court said that it is not clear from all the facts that when the assessee has updated the primary email address and the secondary email address on the portal. Court also said that it cannot be said that the assessing officer is at fault. At the same time, the court said that it is also clear that the assessee has not got the proper opportunity of being heard in this matter. The court said that the assessment order is the foundation stone on which the interest of both the assessee and the income tax authority is there. So if that foundation stone is not strong, then it will create a burden both on the assessee and on the income tax authority in the form of wastage of resources. So depending upon all the facts and circumstances, when it is not clear that whether the notice is issued to the assessee or not, whether the assessee has got the proper opportunity of being heard, and seeing the intention of section 282 and rule 127, this case should be remanded back to the assessing officer for fresh adjudication or for de novo assessment. Friends, the court said that the matter should be remanded back because in this case the assessment is made on a very huge figure. So it cannot be said that the justice has been done to the assessee, because from the facts and circumstances of the case it was not clear that whether the department is able to prove whether they have issued the notice to the assessee according to the rule 127 and section 282 of the Income Tax Act. So in the present circumstances, the court remanded the matter. In this case, rule 127 was also discussed. I am briefly stating about some very important aspect of rule 127, which says that if the notice is to be sent by email or electronically, then the notice should first be sent to that email ID which relates to that assessment year for which the matter is pending. If that email ID is not available, then the notice should be sent to the email address on the latest return filed by the assessee. And in case of companies, the notice should be sent to the email address which is available with the Ministry of Corporate Affairs and In case the assessee has given some another email ID to the income tax authority, then that email address should be used for sending the notices. So there is a proper channel for issuing the notices to the assessee. If that is not followed, then it cannot be said that the principle of natural justice has been followed and there is proper service of notice. So in this case, the notice and the assessment order was quashed and the matter was remanded back. At the end of this video, once again I am repeating the name of the case. The name of the case is 4-Star GRANITE Private Limited versus Deputy Commissioner of Income Tax, and this case has been reported in 444 ITR at page number 161. The matter has been decided by Kerala High Court and the date of the judgment is 29th March 2022. Thank you, friends.